Welcome, everybody, to the Making Awesome podcast. This is episode 203. Oh, it's actually 204. I have the title wrong. It is 204, and we are hanging out with Christa Laser, talking all about prior art and you and why it matters. But you want to hear from an actual patent attorney that knows all about prior art, that did go through that second bar exam. So Christa, if you don't mind, give us the Backstreet Boys, the who you are, the where you're from, the what you did, and as long as you love me.
So I'm Christa Laser. I'm a professor at Cleveland State University now, but I, as Grant noted, have passed the patent bar exam and practiced for about 9 years in Big Law in Washington, D.C., doing patent litigation, as well as false advertising and other intellectual property litigation. But a lot of my work focused on trials at tribunals like the US ITC and district courts around the country doing patent cases, both for patent owners and people defending against patent lawsuits. And let's see, and I'm originally from Canada, but I grew up in Arizona and then worked in Washington, D.C., and then just moved here to Cleveland to teach.
Do you enjoy being a professor now? Or
I love it. I love it.
was it more fun being an attorney, like a full-time attorney?
Yeah, so I loved being an attorney. My favorite thing about being an attorney was depositions because I got to really dig into somebody for, especially if they told a lie. That was my favorite thing because I consider myself kind of a truth seeker. So I love to find some kind of document where, oh, this email from 2009, you said this, and really nail them for it. So that was my favorite. I miss doing depositions and I miss presenting in court. I loved court proceedings, and when I was in law school, I was the world champion of the space law moot court competition. And so that was what got me my job in Big Law, was winning that competition. And so I really miss speaking in front of court, but teaching is great. I really love my students. They are really eager to learn. And it's so nice to just be able to talk about my favorite topics all day, every day, and not worry about any of the administrative stuff.
That's fair. You know what? That's a really fair point. Because like what is a college class other than a jury? Right?
Oh yeah.
They're judging you the whole time. They're listening, they're mostly paying attention, and all the normal things that should occur. But we brought you on because I think it was 7 people sent me your channel and said, you gotta have her on, you gotta have her on. There's a real patent attorney that did a video about this. So if you are like crazy interested about the law and learning about patent law and just intellectual property law in general, Christa has a YouTube channel. We've linked it in the description. Go check it out. Go subscribe. Obviously, go show her some love for also hanging out here with us and putting up with me here on the show, because it's not easy, one, to get into content creation, especially when you're a college professor, you're maintaining a bar license and all these other things. And, you've also told me that you are a cat mom, so that, there's that whole thing too. Yeah, there's a lot going on, and you've decided I'm going to make videos too. And you made your video about the bambulab versus Stratasys, and it got like 10,000 views.
Which is way more. I mean, I'm a super small, brand new creator, so I was a little bit shocked about that, but I'm glad people were interested in looking at the nitty-gritty of some patent claims.
Yeah, people love understanding it, and I think that's the big issue that we've seen, and why we decided to do another live show about this. Is the one big topic that everybody talks about is prior art, and unbeknownst to me, it is nowhere near as straightforward as I want it to be, because of course it's not. It's the U.S. legal system.
Right.
But yeah, there is so much involved with it that adds nuance that, unless this is your profession, It's going to be difficult. Do you want to give a shout out to Custom Unlimited Designs, who dropped 5 memberships to Red Sky Recon, Musin, Mickey Person, This is DD, and Ryan Moore. Thank you so much. And apparently it is 2 a.m. in the morning for them, and they have a flight in about 7 hours, so they should try to get some sleep. So thank you for dropping some love on the channel, and best of luck, get some sleep. And that likely means you are in Australia. Yeah, I think that means you're in Australia. Anyways, and Wexter's here. Wexter's here hanging out. Wexter's is a awesome 3D modeler creator. You guys go check out Wexter if you haven't, and go make fun of him or something. We do have some awesome people here hanging out. Mad Cat USA, Duff, Max H, Thomas, Collie, Bearded Printer. Wow, Collie hasn't made fun of me not getting a haircut yet. Duff is here. He's asking whereabouts in Canada were you originally from?
From Edmonton.
Edmonton?
Yeah.
Okay.
The western side.
See, I don't. Duff is our Canadian guy. He's up in the Great White North, and I'm down in the 32 degrees Celsius south right now. It's terrible. It's too damn cold. Duff's in Winnipeg apparently. It's in the Alberta province. Mad Cat says. See, I like this. See, I can just say I have no clue where it is, and we get people telling us where it is. Wexter says I need to cut my hair.
Thing about the live stream.
Ollie says he gave up. It's the fun thing about a live stream. People can still make fun of me at the same time that I make fun of myself. It works out. So let's dig into prior art. Because when I look at the comments on any of the videos that we've done about Stratasys versus Bambulab, it is always, but this already existed, this already existed, this already existed, and it's been in prior art and open source for years before the patent was even filed. Why can't they just challenge it? And how the heck was this even granted in the first place?
Yeah, so I think when it comes to prior art, a lot of people don't realize, as you pointed out, that there's a lot of nuance to the legal issues of when something constitutes prior art to a patent. Mm-hmm. And I guess we'll have time to go into the nitty gritty, but the overview is that you have both novelty and obviousness as a basis to invalidate a patent. And if you're looking under novelty, you have to prove that whatever piece of prior art you're looking at had every single element of the claim that's asserted. So every time that you have a lawsuit, you're going to have a list of claims that are asserted against specific products. And in those claims, there's going to be a bunch of different limitations, different aspects to it. It's not just, networked printing. It's networked printing with a LiDAR scanner or whatever it is. It's nuance to it.
Yeah.
And in order to be prior art, it has to have each and every element. In addition to that, it has to have each and every element prior to a critical date. Now, if you have patents that are filed before March 16th, 2013, there's even more complexity because we're under the first to invent system, where you have to look not before it was filed, but before it was conceived of by the patent filer, which could be years before the filing.
That one's complicated because first thought is now, if someone didn't take good notes, you're kind of screwed in this.
Yeah, you have to have documentation to prove your first thought.
Now, the nice thing is, in 10 years or so, that doesn't matter anyways, because it's 27 years, I believe, max that a patent can even be enforced before it gets, what's the right term for it? Retired? When a patent is no longer, it just expires? Okay. Yeah. Patent law is very nuanced. It's 20 years of filing, but there's, you can
term extensions.
Yeah, there's term extension. I believe it does go. Is it 27 is the max ability, or?
I think for the ones that are filed nowadays, we'll be looking at 20 years from filing. Okay. For most of those, unless you have a really, really unusual situation.
Or a very large law firm with unlimited amounts of money, which something tells me both of these companies possess. And that's the big thing, right? For those that don't know, Stratasys is kind of the reason that we have consumer grade 3D printing, but not for the reason that you think. They patented some really, 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 really basic things in this industry. And the RepRap project's like, no, we don't like this, so we're just gonna open source everything, and there's nothing that you can do. Now, well, technically that's not true. There is things that they can do. It was surrounded within the education world and not the for-profit world. So all of a sudden it's like, nah, Stratasys doesn't want to play that game of suing schools.
Yeah.
And that's why we have the term FFF and not FDM, because they have a trademark over the FDM, fused deposition modeling versus fused filament fabrication, because of the IP industry. Kali does want to confirm that this is US only, and yes, as far as I'm aware, this is just US law straight up.
You're going to have to be looking there. Now, there are treaties that, and part of the reason why there's that shift in 2013 is because the United States was trying to become in conformity with the international systems.
Okay.
And so post 2013, the US system is a lot more similar to the international systems than it used to be. The primary difference being that the US system still has a grace period for patents that were filed in the United States, meaning that instead of the prior art date needing to be at the time of filing, which is the case in most other countries, the prior art could be a year before the filing if you have some special disclosures that happen within what's called the grace period. The grace period.
Is there a grace period for a regular patent though? So if I was to file a patent and there was a prior art thing, is there a grace period, and what is the acceptable time for that grace period to exist?
Yeah, so for patents that are filed after March 16th, 2013, you're in the what's called the first to file regime,
Right.
which is the one that's more similar to the international regimes. And in the United States, there are limitations basically saying that if there's a patent, a printed publication, or you have something like a public use, or that the product was on sale prior to the filing date, that would constitute prior art. But there's an exception, which is that if the inventor of the patent in the United States has publicly released information disclosing what's in the patent, and they do that sometime less than 1 year before the patent filing date, then any prior art disclosures from other people that happen after the inventor disclosed it are not prior art.
Right.
So that's why it's called the grace period.
Okay. There's nuance to that too, which is always fun. Patents are kind of complicated. It's more than a gold-foiled piece of paper that says nobody can copy you, because that's actually not what the gold-foiled piece of paper says.
Yeah.
The patents are not the, oh, I have a patent, nobody can ever, no, patents are just the start of what the protection against intellectual property violations look like, and it is way more complicated than any of you think. And that's literally why last week Seth told us that patent attorneys, they got a whole nother bar exam that they have to go through. It is not just the one bar exam that regular attorneys have. You had to go through a completely separate and second exam just to become a patent attorney, because there's a lot more of that, technical nuance to it versus the standard system.
And you'll often find that even judges don't feel like they understand the nuances of the patent system. And so we even have a special court of appeals for handling appeals in patent cases, in part because the law is so nuanced in this area that we don't expect the ordinary appellate judge to fully understand it.
There is some stuff going on with judges that we'll get into in a little bit. I do want to thank Bearded Printer for the $5. He says money time. Andrew Rogers with the tenner saying for the prior art fund. Thank you both. I see Photos Mint was dropping by and saying hey as well. So thank you all very much. And of course, if you do want to get in on a giveaway, we have printed solid Jesse filament that we are going to be giving away at the end of the episode. So it's in the pinned comment or pinned chat message. I don't know what the heck I'm supposed to call it, but it's there. Go grab it. Get yourself entered to win some free Jesse filament. It is US only for filament, but if you win outside of the US, I'll send you a shirt or something once we get all that sorted. That's more complicated than I'd like to admit. Merch. It is. See, this is the problem of if you go heavy into content creation, you're gonna at some point have to make merch. And it is very complicated to just trust another company to do things correctly, apparently.
Like your adorable shirt.
Yeah, the long cat shirt. Coming eventually, TM. We used to say soon, TM, but that, we were planning on launching August 1st. And that should give people an idea of how, and that was after a year of working. And the samples that I got in, this is one of them. They have degraded way faster than I thought they were going to, so no. And Wexter says, I'm still waiting for that merch. I know you are, Wexter. You're going to be one of the testers. Don't worry. When we get the process figured out, I'm going to send you a shirt. Don't worry. Wexter's in Croatia. So he is in the EU-ish. And it is awesome for us to know people all over the world because we get to test the quality of the clothing all over the world, which is awesome. So, judges, right? That's been another big contention item here, is that not only are some of the patent claims very, very, very specific, but there's prior art existing for it. Stratasys chose a very specific court, a very specific judge for this, who is known to be the intellectual property judge. One, why is this a thing? And two, why this guy?
Yeah. So Judge Gilstrap is the judge that's assigned to these cases. And one of the interesting tidbits about Judge Gilstrap is that he sort of advocated that he wants to be the judge to hear all these patent cases. And people have tried to guess in scholarship why this is the case for years and years and years. Now, I've heard him speak about it, and he says, look, I just really like patent cases. I have an interest in this area. You always get really high quality litigants. One of the nice things about patent cases is you don't have, nobody who doesn't really understand the law making arguments on behalf of some criminal defendant. It's just a much easier type of case from the perspective of managing bad behavior from litigants when you have a patent case and you've got multi-million-dollar lawsuits handled by top lawyers that have been really focused on federal practice and are serious about following procedure. Those are much more fun to be involved with, I think, for judges that are interested in that and are able to handle looking at some of that new case law. Now, other people are saying, look, it's unfortunate that Judge Gilstrap is hearing so many cases. They would urge, because it's not fair to litigants, it's something called forum shopping. Now, the Supreme Court issued a decision called TC Heartland a few years ago that shut down a lot of the cases getting filed in Judge Gilstrap's division, which is in the Marshall District of the Marshall Division of the Eastern District of Texas. But this Supreme Court case basically said that in order to file in that location, the person that you're suing needs to have a regular and established place of business there in order for venue to be appropriate. However, this does not apply to foreign defendants. So foreign defendants are still able to go file there. And because it's this kind of sleepy little town otherwise, they can basically choose to file in Marshall and know for sure that they're going to get Judge Gilstrap as their judge. So that's one benefit to filing there. Texas also has a reputation, especially in the Eastern District, for having patentee-friendly juries, meaning juries that are very reluctant to overturn or invalidate a patent. And so that's another reason to file there. You also have some improved procedural rules that benefit patentees in that area. For example, Judge Gilstrap is much less likely to grant summary judgment, meaning they're tossing out the case early than other judges. And that's been shown through some statistical models.
Yeah, that is not an assumption. He sees enough cases that this is a statistical probability, right? And his Wikipedia page, if you want to read some stuff, his Wikipedia page is very interesting, where he can have upwards of 1,000 open and active cases at any time. And I would say, but I have a hard time juggling a couple of things at once. I can't imagine what it's like. And it seems like some people tend to take advantage of that fact too, where he's got so many that he has to get through them somewhat quickly,
Mhm.
because otherwise he would never be able to go home,
Well, part
right?
of the reason that he gets so many is because he promises to get through them quickly.
Hmm.
There are certain courts that take very seriously the idea that justice delayed is justice denied. And this is something that's very common, for example, in the Eastern District of Virginia, which is another hot place to file a patent case.
Okay.
But if you've got Judge Gilstrap promising, hey, we're going to get this done super fast, and the other key part of it is fast enough that it might be the case that the patent office doesn't have time to hear it before I decide it, that can help to reduce the risk that the patent office gets the chance to review it. And so filing with Judge Gilstrap with this promise of a speedy trial helps to reduce the risk of the patent office hearing the case in post-grant proceedings.
So literally by getting through it faster, the patent office doesn't have a chance to take a look at it and make their decisions on it because judgment has already been rendered. So they're
Right.
utilizing the fact that he's busy, that he's committed to doing things fast as a benefit to skirt the potentials of the patent office coming and saying, "Hey, actually, hold on just a minute. We have some words to say."
Right. So basically, after somebody files a patent lawsuit in district court, like in this case,
Mhm.
typically the defendant or the accused infringer is going to turn around and file an action in the patent office before the Patent Trial and Appeals Board that is trying to get that patent invalidated at the patent office or canceled at the patent office
Right.
through something called inter partes review, which is part of the post grant proceedings at the patent office. But in order to do that, they need enough time. And oftentimes, courts in other districts will do what's called a stay, meaning they will pause their case while the patent office decides on the validity of the patent and has time to review it. However, it's up to the judge to decide whether to grant that stay or not. And sometimes the patent office will say, look, the judge denied the stay, and they say that they're going to decide validity in 12 months. So why should we look at it and waste the limited resources that we
Right.
have?
Right.
Now, they are allowed to sort of decide in their discretion whether they take on some of these cases, and they might decide that it just simply doesn't make sense to use the resources of the patent office when it's going to be decided by a district court proceeding before they could get to it.
It makes sense. I don't have to like it, but it makes sense. And that is what the bulk of this patent industry has been to me. It's like I don't agree with it because it has clearly been made deliberately convoluted for the small inventor
Oh,
to
yeah.
really have to climb the Sisyphus school of patenting. And for the big inventors, the large companies just say, we have lawyers for this. We don't care. Um, so it's clearly been designed and molded throughout the years to help the big guy. And to be clear, it's not like this is a David versus Goliath problem. This is Goliath versus Goliath. These two companies are multi-million-dollar companies, right? And I used to say that Stratasys was a multi-billion-dollar company, but they've had some rough financial reports, and there are claims from people that, oh, this is just Stratasys trying to dig themselves out of a hole. And certainly Stratasys has seen some better days financially. And this is not assumptions. This is real math. They have not actually made actual profit in a few years. And it's not like they're losing 30 or 40 bucks. They're losing millions and tens of millions of dollars every year. And we just saw was it Mark Forge just did a 10-for-1 reverse stock split to stay on the New York Stock Exchange. The entire industry has been struggling on the publicly traded side. So before you pass judgment on Stratasys going just after this for the money and nothing else, remember, it's everybody. Everybody's having the problems. But specifically, and you and I seem to agree on this a little bit, that Stratasys is likely doing this because Bambu is also patenting things, and now their hands are tied. They have to do this, or they're risking their own intellectual property becoming questions, right?
Well, actually, so this is something fascinating. I agree with you on the basic premise that one potential reason why Stratasys is bringing the lawsuit is to address Bambu's patents. They might be trying to get a cross license, meaning that both parties are going to agree to license each other's patents and then continue to move forward, only excluding other players from the marketplace for their patents.
Right.
But I will say, in patents, this is a little different from trademark law, for example. You don't actually have to bring a lawsuit to assert your rights in order to maintain your intellectual property. So it
Interesting.
won't risk their intellectual property if they don't bring a lawsuit. It just risks their competitive position.
So there isn't, and so this is where my limited knowledge of the patent system absolutely, hurts me. You don't have to actually defend your patent.
You don't.
Is that trademark? That I know there's something in the IP.
Trademark is different, yeah. So
Okay, it's trademark.
Yeah, trademark is
Damn.
very different from patents here because in the trademark space, there could be a situation where if you fail to enforce your right for long enough, consumers no longer recognize your brand as being only associated with your brand. And trademark law is perpetual so long as consumers recognize that brand as being associated with you. So failure to enforce your rights can change how consumers view you and result in losing those rights over time. Whereas with patent law, you have a set expiration, 20 years from filing for most of the modern filed patents. And then you can do whatever you want. It's a right to exclude. So you don't have to exercise it. You don't even have to make anything that fits within the patent scope. You can just sit on it for 20 years and do nothing if you want to and keep it. You can sit on it for 19 years and then sue at the very end. And at the very end, when you do that, you'll get up to 6 years back in damages. And people do that all the time as well.
That's something, one, I didn't know that. So my assumption, my understanding was that they were all like the way that trademarks were, where if you didn't, if you use it or lose it, right?
Only trademark is like that.
Only trademarks are like that. Yeah, so that is news to me as well. And that's fine, right? But we have to understand this. There's a lot of people say that, getting a patent, then sitting on it, not doing anything with it, then selectively enforcing it is, un-American. And I'd kind of argue that that's the most American thing that you can do.
Oh, yeah. 100%. I agree with you. Patents, the way that a patent marketplace works is in part that it because it gives you this capacity to sue at any later time, and it can be bought and sold and transferred. They can be transferred much more easily than something like a trademark can, where you typically have to transfer the goods that you're making in addition to that, and not just transfer the name. But when it comes to patents, you can buy and sell that from another company. You can buy and sell that from another company a few years before the patent expires, which is some of what we're seeing. Some of what we're seeing here too.
Yeah, where Stratasys bought patents from, they bought Arrivo, which also came with patents, and they haven't really done anything with Arrivo, so I'm sure their plan was always to do something with them and not just buy their intellectual property. Companies never buy other companies just to have the intellectual property on their books and never do anything with it. There's none of that's ever occurred in this industry.
Yeah, I mean, it happens all the time. The companies will buy the companies that are going under. They're going to get mined for any intellectual property that could be used elsewhere in the market as a bargaining chip or as a potential to derive extra revenue. One of the interesting things about intellectual property is that if you can come to a licensing agreement before you conduct most of the lawsuit, you've got a revenue stream that is 100% margins.
Yep. Yeah, because that intellectual property, until it expires, technically doesn't cost you much to do anything with, right?
Yeah, just the maintenance fees, which might be trivial compared to what you're actually making from the product.
It will be trivial compared to their cost of the lawyers, I guarantee that.
Yeah,
yeah.
True.
Maintenance fees, what do they tend to run?
So they differ depending on how large of an entity you are. For small entities, they're going to be smaller, but for larger entities, it could be something like $20,000 over time. So
That's
there's
still not that bad.
no, I mean, so if you're talking about a mega corporation,
Yeah.
they can afford the maintenance fees, but then you also look at how many patents are they paying these kind of maintenance fees on.
That's
One of the
fair.
things that can happen if you have a company that's going under and they have 65 patents that they might want to transfer, as in the case of Arevo, they might decide, well, some of these are maybe invalid if they were challenged, and we're not going to continue to pay that because even though a little bit of money here doesn't matter. If you multiply that out over 65 patents,
It
that
starts
really
to
adds
add up.
up for
Yeah.
a company that's not generating any revenue. And so you only want to keep the ones that you think that you're going to actually be able to generate some revenue from.
And of course, there's the one that they used in this case. So certainly there are some things there to look at.
Yeah.
Max H says, although I have YouTube Premium, I like to help where I can for $5. Thank you very much. Shergall for 20, thank you. Wow. Says, I had guessed early on that this lawsuit was because of a cross-licensing negotiation that failed. Is suing a reasonable way to get a cross-licensing deal in the long run?
Yes. Yeah. Suing is a great way to get a cross-licensing deal if you think that negotiations are going to fail. And oftentimes, if you don't have some kind of existing in or connection with the other company, it can be really hard to open up those channels of communication between in-house counsel. And
Yep.
so sometimes this starts with a cease and desist letter, which I believe they sent in this case shortly before the lawsuit. But if the other side doesn't respond to that to say, well, hey, we also have a bunch of other patents. So typically the dance is one side sends a cease and desist saying you're infringing our patents. The other side says you're also infringing our patents. What are we going to do about it? Let's have a phone call. And then they have a phone call and they decide on some value. They typically have lawyers and experts find out the comparative value of the patent portfolio and decide who should pay whom, if anybody, in order to enter into a cross-license agreement. Now, if the other side comes from a different cultural environment where they're not used to that dance, then they might just respond saying, no, we don't think we infringe. We're not going to deal with you. Sue us.
Yeah.
And then you don't get that initial dance of the negotiation happening at that point. And so in that case, you go through the lawsuit, you get through preliminary motions, and the key part is you get to something called a Markman hearing. So a Markman hearing is when the judge will decide what the meaning of every claim term is. So sometimes these claims can be a little bit imprecise. You don't really know what they mean. You might need experts to figure out what they mean. And so after this Markman hearing is when you'll often get settlement in a patent case, because that's when the parties can say, okay, the judge is going to interpret it this way. We know that under that interpretation, the jury is going to find that we infringe. So yeah, let's go ahead and do a cross license.
So I'm not seeing. So I'm looking at the court listener document right now, and the most recent thing was on the 11th, from what I see, where the waiver of service was executed, which is pretty much the other attorney saying, yeah, no, we got it. We know. Don't worry about it. We're in another country.
Yeah.
Is it? I'm trying to ask questions without it being construed as legal advice, because I don't. This is not legal advice. Any of you that think this is legal, you're wrong. It's not legal advice. We're asking questions. It's not legal advice. It is my understanding that companies that don't have nexuses within the United States are more or less, they can do whatever they want, because international patent law, specifically patent law within China, where a lot of these 3D printers are made, the IP over there is very different than it is over here. And the reason that Bambu was able to be sued in the first place is that they have a USA headquarters. They have established a nexus. Hilariously, it's in Austin, Texas, about 4 hours away from where the court case is occurring. But it's because of that they were able to be sued here in the States, correct?
You can bring a lawsuit against a foreign entity in the United States as well. And I believe that several of the defendants in the case are the foreign entities
They are.
here. And so in that situation, you sometimes have to go through a special process for serving a company internationally. So it really makes things a lot easier if they agree to waive that process of service. And in that case, they get an extension of time in order to respond if they agree to waive service.
Because my understanding is actually both of these companies are not USA-based companies. Just in looking, Stratasys appears to be Israeli. And
So anybody that has a US patent can bring a lawsuit in the United States,
Yeah.
regardless of whether they're headquartered here.
Makes sense to me. John Stern is saying that we go through patents and cull ones that don't make sense to maintain. I often get asked by our patent legal team to review old patents and opine on whether they are worth maintaining. And yes, for smaller companies, obviously, this can be a much more serious thing to go through. But when you're valued at over $500 million, it might just be the F it, we don't care. Just add it to our list of ones that we have to maintain. But certainly,
I think even big companies do this process of culling through. I've seen this happen, at Fortune 500 companies, that they'll ask engineers to go through their patent portfolio and decide what they don't want to file a maintenance fees for. And that's because some of these companies are going to have 1,000 patents that are going to be coming up for let's say you've got the 11-year fee is going to be almost $8,000. And so if you have 1,000 patents coming up for $8,000, that's going to really hit you. So big companies care about this too if they've got a lot of patents.
That's fair. And John Stern says, my God, they have over 2,200 patents with the company that he works with. Jeez. Yeah. That's a lot of maintenance fees.
Yeah.
Yeah, that's absolutely nuts. And as Madcap points out, we have 110 people watching now, and only 32 likes. Those are rookie numbers. We need to pump those numbers up. And don't forget, there is, of course, a giveaway for Printed Solid. It is linked in that pinned chat message. So if you do want to get yourself some filament, go over there, fill out the form, and we'll give away a couple of rolls at the end of the episode. But I want to talk more about this idea of prior art. And specifically I want to find the right one. It's the RFID patent. Because that one is the one that even I'm like,
yeah, the 466 patent. Looks like
we have that.
One. Yeah.
Oh, it's always, patents are always fun to find.
Yeah,
let's see.
10, 5, 6, 9, 4, 6, 6.
B2. What's the B2 mean?
Not important. It's
Okay.
You can typically toss that off the end of it when you're talking about the actual patent numbers. It's just some administrative nuances, but it doesn't matter.
So I'm going to read the abstract verbatim off of Google Patents. I'm sorry for those of you that are going to get a headache from this. A supply of build materials, such as a spool or cartridge, is instrumented with a data tag that includes information about the build material. A three-dimensional printer can read information from the tag and determine how to use the build material during fabrication of a three-dimensional object. So we've got, that was filed, what, 10/5 of 2018?
Yeah.
By MakerBot.
Yeah.
Who is now, of course, owned by Stratasys, and at the time was owned by Stratasys, which is interesting. That it wouldn't be filed under Stratasys, it would be filed under MakerBot.
Yeah, whatever the entity that they have the employees and the inventors under, they're going to file it under there, and then at a later time they might transfer it to a holding company.
So there was a company previous to this that was big into the DRM filament called XYZ Printing, and they had the Da Vinci line of 3D printers. And apparently Chaucer works for GoPro. Who knew? I didn't know. I feel like I might have known this. That's pretty cool, working for GoPro. But Da Vinci, the Da Vinci line of printers, if you all don't remember those machines, you're lucky. They were not good. But they had this rampant issue of they used a cartridge system for their filament, which was locked with an RFID system. Hilariously, the maker community doesn't like that kind of thing, and within 6 months of it being released, a hack to get past it was also released, and it was effectively a way to just reprogram the EEPROM chip on it to reset. It is so frustrating that companies that used chipped filament do this, but they'll tell you the spool is empty when the spool is not empty.
Oh no.
And that's frustrating.
Yeah.
And so you end up with a bunch of extra waste, and then the cartridges are made of plastic, and that's a waste, and there's just so much waste. Anyways, makers got pissed off at this. They found a way to just create your own tags or reset the ones that were on those cartridges to be able to reuse it. This was in like 2014.
Yeah.
So, one, how is that not obvious prior art? But then two, how did they even get this patent in the first place? Because it feels like the USPTO, if I knew this, and mind you, I am what the U.S. Navy SOCOM calls a subject matter expert. Now I can say that the U.S. Navy SOCOM believes that because they do. I just think I'm some random guy that has a insane level of knowledge that no normal person should have. But I knew about this. So why didn't they find this?
It might actually be not because they didn't find it, which can happen, but also could be because of the priority dates, that it might not have constituted prior art. So if you look at the cover here, it says filed October 5th, 2018. But if you scroll down, it says related U.S. application data, continuation of application number 14/992 filed on January 11th, 2016. Which is and then you should find somewhere else in this document, it'll probably say, which is a continuation of some other thing that was filed earlier. And my guess is that the priority date, meaning the sequence, goes all the way back to 2013. So anytime you see continuation, you don't look at the filing date on the cover of the patent. You look at the filing date on all the way back in the chain. What patent did that emerge from, or what application did that emerge from?
And it looks like, so there's an application number from October 29th of 2012 where the entire content of each of the foregoing is hereby incorporated by reference. That would be before XYZ did it, so
it says, October 18th, 2013 was the filing date of the very last sequence in the chain. So the prior art here would have to be, and interestingly, this is after the March 16th, 2013 critical date for the application of the America Invents Act, meaning we're still looking at first to file, but it's the United States, so we have the grace period. So the prior art date would be, assuming that they did a publication in 2012, if they did a publication October 29th, 2012, the prior art needs to be before October 29th, 2012 in order to be invalidating.
Which, as far as I'm aware, it wasn't. It was 2014 is when the first XYZ Da Vinci with chipped filament came out. Okay, so I feel a little bit less pissed off about that whole thing. Because, like, I'm sitting here as the average user like, excuse me? What?
That's what happens if you have somebody that doesn't understand all the nuances of the statute. You're just looking at the cover and saying, it's filed in 2018. This is ridiculous. This all existed before then. No, you have to go walk through the entire statutory framework, figure out which statute you're under, which provision you're under, whether a grace period applies. And that's just to figure out what the date of prior art needs to be. After that, you also have to go look at the claims of the patent that's asserted. Did they assert the claim that has that particular thing that was present in that piece of prior art? And maybe they chose to assert claim 1 instead of claim 15 that had that information. So the key is you have to go down to all the way down to the claims. We don't even look at the abstract. The abstract doesn't define the claims.
That's fair.
You go down to the claim that's asserted, look at each element. And in order for it to be novelty invalidating prior art, for the geeks, it's section 102. For it to be novelty invalidating prior art, you actually have to find every aspect of the claim element in the prior art for it to be invalidating.
I'm being corrected quite a bit in the comments. I want to go through what people are saying. So let's see. First off, they're saying that it wasn't RFID, that it was electrical contacts for an EEPROM. So, okay, that could be. That is different. I didn't go too deep into the claims because it is so unreasonably... It is... patents, that the thing that upsets me so much about patents, they are vaguely specific.
Yes.
Because you want, there is a line, and
Yeah.
the line is also vague, to my understanding, of how vague you can make a patent before it is too vague.
Yes.
And
So there's a provision for the nerds. Sorry to interrupt.
no, no,
I'd
no, no,
love
no.
to talk to nerds about this, but there's a provision for the nerds called Section 112, which is if you're too vague, they'll invalidate your patent for being too vague. But until you hit that point, which is a pretty tough, a pretty easy bar, I'll say, then you can be a little bit vague in your claims.
So you're saying that if I get 99% of the way to too vague, we're good.
Yeah.
And see, that's what a lot of patents do. And we work with a lot of inventors, and inventors they're like, we need a patent. I'm like, no, you don't. You need money. You need sales. You don't need, I'm sorry, I'm saying this in front of a patent attorney, but you don't need a patent. You need money. Because to file a patent, the average person does not know how to talk in patent terms, because patent terms are so different than regular terms.
One thing that I would recommend. So you mentioned that a lot of your followers are people that are makers. They like to do everything themselves. They probably don't want to hire a lawyer to do this.
No.
Something you can do is if you have a science degree, an undergraduate science degree, you can apply to take the patent bar exam. You don't have to go to law school. And if you do that, you can become a patent agent.
And you can file your own.
Is a lot. Well, and you can file your own even if you're not a patent agent, but in order to do it right, it's helpful to understand all the things that you would need to know to go through the patent bar exam. I mean, you can always just study it and then not take the test, but if you're going to study it, you might as well take the test. And so if you've got that science background and you want to do this yourself, go study for the patent bar exam. It takes about 3 months, I'd say, of full, 8 to 10 hour days of somebody studying this stuff.
3 months of 8 to 10 hour days of studying?
Yeah. That's typical for a bar exam type thing. You can spread it out over a number of months. I took like 10 months part-time looking at it.
That's a lot of how many pieces of paper is this?
Oh God, it's huge. The manual, I had a hard copy thing that I looked at when I was doing it. It was like this thick.
I'm getting stressed just thinking about it. I have business degrees, but I'm basically an engineer as far as most of our clients are concerned, but I have business degrees.
But it's not daunting. For somebody that's an engineer, you'll love it because it's basically like, okay, look at section this if you have this problem. Look at section that if you have that problem. Where, what does the manual say that you're supposed to do? And so if you memorize the manual and like where you can find it in the manual, then you're fine. And you can get through that exam, no problem. An engineer is not going to have a problem taking that exam. And especially you're allowed to take it as many times as you want.
But there's a cost to it. It's not like you just like, I'm gonna go spend my Saturday taking the patent bar exam because you know what? I hate myself.
Yeah. But I will say this is something you can do yourself if you study up on it. And it's not impossible. You don't need a lawyer. And if you do that, then the only cost that you're looking at the biggest cost of this is the attorney's fees.
Right.
And so if you're looking at this and if you're a micro entity, meaning this is your first time doing it, you're not making a ton of profit yet, those filing fees are super low and the maintenance fees are super low. For a micro entity, the total maintenance fees are something on the order of $2,500.
Yeah. Yeah. It is not much when you are a solo or a very, very small company doing inventing. I would argue for sure that if you are looking to do a patent yourself, that at least you studied. You don't have to take the exam. Maybe you should, but
study the kind of material you would need.
Yeah,
and if you want to do this,
understand the language.
Yeah. The Manual of Patent Examination and Procedure is up on the USPTO website, and it guides you through every question you could possibly have on filing a patent.
John Olson says, what? Armchair lawyers don't know everything? I'm shocked. I'm shocked too. Who knew that all the armchair lawyers in the YouTube comments, and even the idiot that's talking about it, hi, I'm the idiot talking about it, don't know what actually they're 100% talking about? Who knew? And that's some of the assumptions and the things that we thought were real and obvious. And no, kid, sit down. Class is in session. Professor Laser is here to tell you that you actually don't know most of what you think that you know. The entire system is different than you think, and prior art is not as easy as you think it is. Time to get schooled with Professor Laser. Now that would have been a cool title, but no one would have understood what that would have meant. These people get it now. Still awesome last name, especially because Laser. If you were into laser, that would be so cool.
Yeah. I
Professor
think I
Laser.
mentioned when we talked
Yeah.
earlier that I used to work in laser spectroscopy before I became a patent lawyer. And so they were always, everybody at the lab was like, you have to stay in laser spectroscopy so you could be Dr. Laser, the laser spectroscopist.
It's needed. You just gotta go back. See if you could just get like one of those where they give the degree from the college, so you could
Yeah.
get just so you can be that, you know, where it's worth it. I'm saying it's worth it. And we got a lot of people saying that they got a master's in BS. Andrew Ryder says he's got a master's in BS, but he doesn't think that counts.
No, it counts. You can take the patent bar with that.
No, the master in BSing.
Oh, BS. Oh, I thought you meant a BS degree.
No, these individuals
Bachelor of Science.
they're not talking about bachelors of science.
Oh, I'm so naive.
Mad Cat responds saying most of us have a master's in that. A few of us have PhDs.
Oh man.
Yeah, you know, I got a BA in BSing. Yeah, it's you know. And John Stern says I always have a headache after spending time in the bar. So yeah, you know, it makes sense. It makes sense. Yahweh is saying, how about we look into printer ink as prior art? I don't want to go. I really don't want to go down that rabbit hole. That's a deep dark rabbit hole of problems.
Can we please though? There's actually a really interesting thought.
By all means, go ahead. It frustrates me, but everyone likes the Grant rant, so we can do this.
So with printer ink, if you have a technology in another field that is relevant to the field here, what you need to do is you would look under the Obviousness Statute, which is section 103. And what you need to show is that it has all or most of the elements, and any missing element would have been obvious to a person of skill in the art. So if we look, for example, at the patent, let me pull it up, and on the tags, the RFID tags, one of the pieces is a method comprising providing a three-dimensional printer that includes a tag sensor, and then there's a bunch of other elements there. But you could see if you had a printer, like a physical 2D printer, it wouldn't meet one of those elements of having a three-dimensional printer. And so therefore, you wouldn't be looking at novelty as the basis for invalidating it. But you could potentially get it under the Obviousness Statute by showing that there was a piece of prior art, like a patent, a publication, or a manual or other evidence showing prior public use or something being on sale that has all of the elements except for a 3D printer. And then you would prove that that missing element is something that would have been obvious to a person of skill in the art at the time the invention was made. Courts have a huge bunch of multi-factor tests that they look at, but one of them is how likely is it that somebody who knew about 3D printing, was an expert in 3D printing, would be looking at the art in two-dimensional printing to decide what to include in a three-dimensional printer. And if you can prove that they would have knowledge of that, then that could factor in to say that it might be obvious.
I would argue that they were. I mean, literally, I have a 3D printer that uses HP11 inkjet heads. So I not only would argue that they would, I can prove that they did. Because all that full color 3D printer that I have does is it pulls out a piece of paper. It's not, it's powder, right? It spreads a layer of powder, puts ink on top. It is an inkjet printer. It's just a big one. And then the bed goes down a little bit. It pulls out more powder, does the same thing, lather, rinse, and repeat. It's exactly how this works. The big issue with it is HP no longer makes those inkjet heads, and it's becoming a problem to obtain them. So
yeah, so if that's potential obviousness-based prior art, you would look again at the date. The same critical date could apply somewhere in the 2012 or 2013 range, and you would need some documentation or evidence like a manual or publication that was showing that all of those elements were there. Now, I think on the other side of that, if this were in court, the patent owner would say, well, it's not just having a tag sensor on a 3D printer. There's a lot more to the claims than that. And they would look through the claims to see what else is missing. And is that something that they really could have incorporated with the existing amount of knowledge? And would it have been obvious rather than this actually being a new innovation to take that printer tech and put it into 3D printers? Was there something that made that hard? That's one of the factors that courts consider. You know, if one of the things is if there's a long-standing unmet need and nobody meets it until this person comes along who's the patentee, that can show, well, it must not have been obvious if
'Cause
we
nobody
didn't have a
did it.
rush of other people all doing it at the same time. So that obviousness factor is really wishy-washy and something that you're going to need to prove with a lot of economic considerations at the time to prove that it would have been obvious and not actually an innovation.
That's the one that is often the largest challenge for inventors, is dealing with this non-obvious problem of, okay, if you're the first one to come up with this, let's look at, would someone who's an expert be able to do it? How long has this tech theoretically been available? It is where I tell people this is, again, for the average inventor, because it's like, if you aren't, if you haven't taken the patent bar and you're not a patent agent and everything like that, it is on average $15,000 to take a patent through everything, because by and large, the first time you submit a patent, they're going to tell you no. I don't know why. It's just the way that it is. And we've actually seen customers submit the exact same thing and get it approved.
Yeah.
The second time. It's the office being very busy is our general understanding of it.
Right. I think part of it is that the office is super busy and they want to put some burden on the patentees to come up and say why they think they should be granted a patent instead of having the examiner be the only one who's responsible for trying to prove this one way or another. So a bit of a dance or a back and forth. And you're right, the examiner will typically find some basis for rejection in the initial response.
Yep. Yeah, it's frustrating. And it's a multi-year process too. So once you file, the work is just now starting too. You have to answer any questions that they have, deal with any rejections, fix any things that happen with those rejections. And even then, it still becomes a problem.
And here's where it can become dangerous to do this without either having a lawyer or going through the process of really understanding the patent manual in depth. You can work to get a patent through to being granted, but in the process of doing so, you made it very hard for you to assert infringement against somebody else. Because one of the things that there's this concept called prosecution history estoppel. It's a big word, but it basically means that if you change your patent during the patent process of going back and forth with the examiner, you change it and you make it more narrow. Because let's say they say, hey, this was always available in the 2D printer market. How is this different? And then you say, I'm limiting this to a 3D printer and it's going to modify the way the 3D printer operates in this way. And that's how it's different from the 2D printer. So you're changing it, you're making it more narrow. Well, then if you go try to assert that against somebody else that just uses the prior art that you tried to kind of claim around, you're not going to be able to assert that. The patent office, the work that you did is basically going to make it so that you're stopped from asserting your patent against people that followed the prior art.
Yep. This is why I just hire attorneys, man. This is why you hire attorneys, because
you can do it yourself. Just if you're going to do it, go put in the 3 months to really understand the system.
But do you have 3 months?
Right.
It's like, okay, you could do 10 months part-time.
Yeah.
Right. But for a lot of inventors, especially first timers, they are potentially working day jobs. They've got bills. They've got all these other things that are already consuming all of their time. And yeah, does it make sense if you're just going to go and be a patent agent that you start a business being a patent agent? Or do you also need that first bar exam to file patents for other people?
You can be just a patent agent and you can represent others before the patent office. You just wouldn't be able to do some of the things that attorneys would do. But a lot of people just are like, hey, I just want the patent. And if all you want is the patent agent can draft up the claims, do response in the initial proceedings with the patent office.
Okay. Yeah. Seems to make sense to me. So when we look at the real, so I want to say the real concern with prior art, but we've covered the RFID. That one is, I mean, it was right there in front of our faces, and I didn't understand it, and clearly nobody else did either. And I clearly didn't do a good job of explaining it because I didn't understand it. I am still surprised that Stratasys' lawyers have not gotten back to me. I called every one of their offices. None of them wanted to comment, which is hilarious to me. But why so many patents? Is this just, we believe we can hook them on one, let's just throw the book at them with all the ones that we have? Are they required to do it this way? And also, why 2 lawsuits? Are they limited in how many things they can claim per lawsuit?
So, under the federal rules, which govern the number of things that you can bring within a lawsuit, you're not limited in the number of claims you can bring. So there's no reason under the federal rules to say, let's, why not put 65 patents in one lawsuit? You can totally do that if you want to. But judges have individual rules for case management, and they might require at some point along the line that you narrow the scope of things that you're going to bring to the jury. And so filing 2 lawsuits can sometimes help to address concerns around the individual judge's procedures for limiting the scope of claims for the jury trial. And then another reason to bring it as 2 lawsuits, of course, we'll never know why they brought it as 2 lawsuits. It could also just be that they had different teams working on those lawsuits because they cover different types of technologies. So sometimes in order to avoid administrative burdens, you might have the team that has expertise in kind of more of the physical type patents might be operating on that one, and the ones that have more of the software knowledge might be operating on the other, and they don't want to have to coordinate on every single thing. And so that's another reason to do it as 2. Another one might be because some of those patents are more susceptible to challenge for invalidity, and they wanted to separate out the ones that could potentially slow down the other lawsuit. So there's a lot of interesting ways to think about it, and we don't really know exactly why they decided to bring it as 2. They would be allowed to bring it all as 1 if they wanted to.
Okay. So I guess my thought, right? But I should just keep a tinfoil hat anytime that I talk about this lawsuit, because everything that I have is just tinfoil hat theories on this, right? My thought was that by separating them, they had a better chance of at least one of them sticking between the 2. So it's like when someone gets arrested for like a major crime, they'll have like 30 separate charges, even though, all right, we really want to get them on the 1st-degree murder, but we're going to try them for all of these things. So if they try to plea down, we can still get them for something. If we can't get them for murder 1, we can get them for other things. That's what that felt like to me, where they're separating it because they've got a better chance.
It's quite possible that they decided that, my guess, if you were going that route, might be that, maybe they decided that, let's say the 645 lawsuit, they feel better about those ones from an invalidity perspective. And so maybe they're going with those ones. So that's certainly a possibility as to why to do that. Another one might be in order to time the risk of a stay. Remember I mentioned that if bambulab were to go to the patent office and say, I'd like a post-grant review of these patents, it might be the case that some of them have a better chance of getting granted by the patent office for post-grant review. And if that happens, then that could affect the timing of the lawsuit, and they might have chosen the ones that they thought might get subject to that patent office review to go in one bucket, and the ones that they don't think that's going to happen to go in the other bucket. That's another possibility, but we just don't really know.
I'm looking at my comments right now. There's a lot of people saying, "Oh, all these other companies, all the other companies should band together and support Bambu. I'm over here like, no, they should be very quiet. Pretend they don't exist until this is all said and done.
Yes.
And just hope that they don't make enough of a ruckus to be included in this lawsuit. It's so odd to me that people don't see the potential problem of every, like if Prussia, Creality, Soval, everybody said, oh, let's put a GoFundMe together for Bambu, like Bambu needs more money. But then they're just implicating themselves in all of this, aren't they?
Well, it depends. So there's a few strategic choices here.
Okay.
One thing would be that they could wait to see if Bambu reaches out to them to say, hey, I think you guys are at risk as well. We are planning on challenging this at the patent office. Would you like to form a group that could jointly challenge this at the patent office, because you are probably next in getting sued? Now, if Bambu is successful at convincing them that they're probably next in being sued, then maybe they would join together in the patent office proceeding. And they could do that through a shell company that's funded by all of those organizations. So that's another way to do it potentially. But the other option could be that they sit back and wait. They see how the judge interprets these claims, and they might be waiting to see if this ends in a cross license. Because if it ends in a cross license and then they go, try to put money into something, then they're just wasting their money. They're going to get sued for it. So, do they really want to do that? And they could also decide to bring a separate action if they wanted to, or challenge these claims separately. If they don't think that Bambu is going to do a good enough job, or their lawyers are going to find everything, if they feel like they have better lawyers, they might wait to see how Bambu does and see if Bambu can succeed. And if it can't, then they get another bite of the apple at proving invalidity when Stratasys sues them.
If Stratasys sues them, yes.
Yeah.
Because Stratasys has been pretty quiet for the past, I don't know, 15 years. For all of this, there has not been, like, the last major lawsuit that we saw in the consumer-ish industry was 3D Systems going after Formlabs for the Form 1 for the stereolithography patent, which 3D Systems had them dead to rights. Like, and it ended up in a license deal where Formlabs paid out, right? And they paid a license fee. It was never, obviously, told how much it was, but my understanding was that it was for only the Form 1, and that's why the Form 1 had a very short life cycle, and they went to the Form 2 very, very quickly. When we look at, and David Connor Shover asked, he said, what are the potentials here if it does actually go all the way to court and Bambu straight up loses? Like, what are the potentials here that could happen?
Right. So we have the district court proceeding, but we also could have other proceedings, like one in the International Trade Commission that would block importation. That could happen faster as well if they end up deciding to file that.
Mm-hmm.
But let's look at just the district court proceedings. What could happen if the district court proceedings go all the way to the end? One option is that the court could issue an injunction.
Okay.
And the court has this power of equity when it comes to injunctions, that they can do whatever they think is fair and make whatever judgment that they think is appropriate to stop the harm that's occurring. And they would balance out the potential harms to the public and to the other side when they're making that decision. And so the judge likely in a patent case will issue an order saying that the infringer is no longer allowed to make, use, and sell devices that contain the infringing technology. And then they might give them some period of time in order to make those adjustments. So sometimes they'll say you can have 6 months to redesign your products to no longer have this, and you're allowed to continue to make, use, and sell while paying royalties to the other side while you do that. But oftentimes they'll just say, look, you got to the end of this, you lost, you're cutting off sales of that today. And at that point, they're no longer allowed to make, use, and sell in the United States. until they make a new product that doesn't have it. And sometimes that can take 6 months to 2 years when you're talking about redesigning entire product lines with physical features. There are some aspects that might be able to be implemented faster. So for example, for the 774 patent in the 645 lawsuit, which is about the use of printer configuration information. The accused product there is the Bambu application, not the physical product. And so you can imagine that with that, it could be pretty instant to get a fix in place to design around the patent. And so some type of order there could be, hey, you send out a firmware update and that could, or a software update that could change how these things are implemented. And then you don't have to worry about future damages. In addition to that injunction, you could also have monetary damages for the last 6 years of infringement prior to the filing date, and any infringement that was ongoing during the course of the lawsuit, which can be a few years long. And so that damages award could result in higher prices for consumers.
And it probably at some point will, because a cross-license deal is likely going to also result in higher prices to consumers at some point.
Not necessarily. Only if one side has more valuable patents than the other. And it could be that they both equally value each other's patents. I've seen many cases with these huge lawsuits against Fortune 500 companies where they'll still say, hey, I want to do a cost-free cross-license.
Then why go to court? Does that just force people to sit down at the table and start bargaining like adults rather than children?
It forces people to do the dance. When you go to court, you force people that aren't willing to dance to come dance, right? If you want to get people to do the negotiation dance, sometimes that can be difficult when you have two different cultural backgrounds, or two people that are approaching it two different ways. They might not really understand how to do the dance together the way that the other person wants to do the dance. And part of again hiring a great lawyer for doing this is hiring somebody that understands the culture of not only your company but your opponent's company. So for example, when I was doing some work for a German company that was suing a Chinese company, I went and brushed up on my German. My mom is German, so I went and brushed up on my German. And we had a colleague that knew Chinese that joined the case, and it wasn't just the language; it was also understanding culture. And so coming in and saying, okay, we want this person to come into a meeting. I knew the German client is not going to tolerate having plastic cutlery. And so no plastic cutlery, no disposable things anywhere in the room with the German client, right? And the Chinese, the person who had more understanding of Chinese culture would come in and say, look, you have to show some signs of respect before they're willing to engage in this discussion with you. You can't just walk in and go straight into business. And so you have to show that you respect what they're doing.
Right.
And this cultural knowledge is necessary for engaging in that dance. And so if people can't match cultures to engage in the dance, the lawsuit is the way to force them into it.
Got it. Interesting. Because again, a tinfoil hat theory that I have is that Stratasys wanted to buy Bambu. That didn't work out. And, Stratasys said, okay, we'll sue you for everything you got.
Right. There's so many business reasons, right?
Yeah.
And it could also be that Bambu was starting to encroach upon their customer base with some of their newer models. And you see in the lawsuit, I mentioned this in my video, that one of the interesting digs that was in the lawsuit was, hey, you guys are not as secure as we are. And you're like, there's no network security patents here. Why are you talking about the other person not being secure? And that's because they're trying to say to their customers, hey, don't use this bad guy, right? And that tells me that maybe this is about Bambu taking market share from Stratasys, and it might not be a cross-license question.
There is certainly some pretty valid arguments regarding this, but hilariously, it would be with MakerBot and not with Stratasys. And Stratasys owns MakerBot, so it's, one and the same. But yeah, the Bambu X1 carbon, right, of which your husband has one, right?
Yeah.
And he likes it.
Yeah.
I have one as well. I'm less of a fan, as people are well aware at this point. And one of the big things that I have problem with on these machines is their network security, and more specifically, their full lack thereof. It has gotten better throughout the years, but it was a little rough when everything first started. And these machines have gotten so good. If you ignore the security issue, they've gotten so good that, yeah, for someone that is looking at like a MakerBot method or the Stratasys F170 to F370 series, an X1 Carbon or an X1E, for that matter, is a very compelling argument. Very compelling argument. And when they are 1/10 the price, there's a Stratasys F370. It's 355 by 355 by 315. I only know that because the Fusion 3 F410 that's sitting up on my shelf is the exact same build volume. I wonder where Stratasys got that from. Allegedly. And sure, that machine can do bigger, but often most companies aren't, right? And so for the bulk of their stuff, they can run it on even the X1E at close to $3,000. It is still 1/10 of the price of the F370 and somewhat close to that of the F270 and F170. And so for a business, unless you're doing like ITAR stuff where, sorry, you're running Stratasys, yeah, there becomes okay, from the purchasing department, like, you're telling me that this machine costs this much, but this machine costs this much, and it can do basically the same thing. And it's, why are we looking at buying this expensive machine? There's absolutely some potentials here of Bambu eating up market share of Stratasys.
And part of the argument from a patent perspective for damages is going to be,
Mm-hmm.
did they use the patented technology in a way that results in them being able to capture more of the market?
Is that a requirement that they have to use that patented technology to capture the market?
No, but it does
Okay.
have an effect on what the scope of damages is. So the damages calculation itself can be incredibly difficult in these patent lawsuits, and there's more than a dozen factors that go into how you determine the appropriate amount of damages in a patent case. The most important of which is going to be what would have been the likely result of a negotiation that
Mm-hmm.
happened if they had actually negotiated it. But looking at that, you might look at how much of the market share did they capture, how much did they sell in order to get where they are, and how much would they have paid to be able to do that lawfully. And so that's going to factor into the damages analysis. If you can find, usually an economist would be brought in to handle this. So if you can show that if they would have had to pay in advance, they would have paid 5% of the purchase price, and be willing to do that in order to continue to have that feature on the device, then that's going to factor into potentially paying an equivalent of a 5% royalty on all of their profits.
So you were talking about the 357 patent, which, from my understanding, is the infill patent, and because it is the method of building an interior volume with voids. That is the infill patent. Here's where things get kind of interesting.
Yeah.
They're going after Bambu Studio for this, right? Bambu's slicer. Bambu Studio is actually a slightly modified copy of Prusa Slicer, which is a modified copy of Slicer, SLIC3R, Slick 3R, as Tom Sodlotterer has coined that term. So can Bambu just effectively like, bro, we just copied somebody else's homework here. This isn't us. This is an open source program that we added to and we partially rewrote for our machines to operate within their cloud environment. But the infill thing, brother, that's been around for decades. And that patent has also been around for decades.
Yeah.
That patent was filed in 2006. So it doesn't have a lot of life left in it.
Right. Right. So I will say the one that's accusing the Bambu Studio app is actually the 774 patent, the detection and use of printer configuration.
Okay.
I thought with the 357 that the accused products are the physical devices.
Well,
but it would be worth checking the lawsuit there.
I will need to check that. I'm not 100% certain.
But
That's
if we're talking
lawsuit
about,
one.
I can still answer the question about open source and how that plays into it.
Yeah.
So let's say for the one where the accused product is the Bambu Studio app, which is the 774 patent on use of printer configuration information.
Mhm.
When you have something that's open source, no, you unfortunately can't have a defense of saying, look, I used somebody else's thing that I was authorized by them to use, because the only way that they can give you that authorization is if they not only had the authorization from the patent holder themselves, but also they had the right to grant you a sublicense and they did so.
Mhm.
So if you use some open source piece of information, you still have to worry about third parties that are not parties to that open source licensing agreement having some patent that is potentially infringed by use of the open source software. So this can happen also a lot in the context of standards
Okay.
or patents that are subject to standards. One of the cases that I litigated was about video encoding standards. And one of the ways that we proved infringement is that the accused infringer was saying that they followed this standard, and we were able to show that using that standard incorporates this patent. So it's something where you're not going to get out of liability simply because you're using an open source or even because you're using a standardized approach.
I did just check
Accused products.
the accused. It is every one of their printers. Yeah.
Yeah.
It's every one of their printers. They are referencing Bambu's wiki of like, come on, Stevie Wonder could see this.
Yeah.
But if that patent is actually ever upheld, literally every 3D printer on the market that isn't paying Stratasys is yeah, they're guilty as charged. If and that's probably why Bambu doesn't want this to head to judgment. They will likely want to settle this and get it out of here quickly, because paying that royalty is much easier than, well, especially if the 357 patent can get upheld, basically deleting your company.
Right. I mean, if you can't design around it, then you're going to have to pay the royalty or invalidate the patent. And I think that they're probably going to go with this patent. They're probably going to go the route of trying to invalidate it based on prior art. And the problem is that this patent, because it was filed in 2006, we're looking at the pre-America Invents Act version of the statute for novelty. And so in that situation, for the novelty section of the statute, which for the geeks is section 102A, that one we're looking at who invented it first. So if they conceived of the idea of doing this in 2003, then you have to have prior art before 2003.
Yeah,
and
Bambu doesn't have it. Right? Bambu doesn't have it. The industry, I don't think, has it. Yeah, I mean, Bambu wasn't a company before like 2020, and prior to that, most of the people that founded Bambu were DJI employees. So, you know, this wasn't their core focus for 2 decades, and then all of a sudden they popped out of nowhere. And to be clear, they certainly had a lot of time invested into this company before they launched it, because yeah, they did kind of come out of nowhere and develop a industry changing machine. And I think that's part and parcel as to why they're targeted here, because they did make the biggest splash. They are one of the best known companies in this industry, and it has effectively happened overnight.
So I think you're right. It's probably a competitive business decision to bring the lawsuit against bambulab here.
Yeah, I would guess there too. Candid Prole is one of the dissenters of patents. They have showed up here as well. They're saying patents are garbage. Stratasys only knows bad PR. Patent law makes you want to puke, or makes me want to puke. And patent law is complicated. It is very nuanced, but patents do have value, and they're not garbage. Now, The argument that a lot of people have made is that patents that are just shelved and nothing is done with, and then they're selectively enforcing it, that is not within the spirit of the system. And I could agree there that it's not really within what the spirit of the patent system was originally. It is what it has certainly turned into.
I actually disagree. So, as somebody
Really?
who looked into some of the history of, I agree on the premise that the patent system has a lot of core values that are
Hmm.
essential for creating innovation in society. And that if for certain types of industries, if you don't have patents, you don't have innovation.
Right.
And that's especially true, for example, take pharmaceutical drugs. If you have pharmaceutical drugs where there is millions and sometimes billions of dollars of development that go into the creation of a novel pharmaceutical, if you can't get exclusivity in the marketplace
Hmm.
and high prices to the marketplace to justify recouping that $1 billion investment, you're not going to conduct the $1 billion investment. And so patents are the only way for companies to, in the pharmaceutical space, for example, to have an incentive to commercialize, to research and to commercialize their inventions. Now, you're talking about the original origins of why we have patents. That becomes really fascinating. So historians have two different viewpoints, and now I'm going to geek out a little bit. But
Please. I know one
historians,
of them. I didn't know that there was two. I know one of
yeah,
them.
there's two.
I'll be
So
curious.
I spend the first day of my class with my students going over the theories of
That's
why we
cool.
have intellectual property. And every type of intellectual property has a different philosophical basis for why it's justified and a different historical justification. When it comes to patents, there's two main theories of thought. Um, One is that there's a sort of what's called a utilitarian approach that if we grant patents, then and create exclusivity in the market, we're going to have more efficiency in the marketplace because only one company is going to be expending money to commercialize and sell something that fits within the scope of this patent. And that can mean that you get higher quality goods and less people spending money on things that may not pan out, or and less of this sort of fight to the bottom of pricing where you get very little margins and therefore have no money left over for research and development. That's one approach. The other is a almost a personhood theory. This idea that something that you create from your mind should be owned by you for a period of time. And if we look at the Constitution to the United States, intellectual property law is one of the only laws that's mentioned in the Constitution because this idea of autonomy over your own creations was so essential to the founders. They actually put it in the Constitution. So this personhood theory, this idea, you're creating something, you deserve to have a reward from that for creating it and bringing it to society. And one way that we do that is through the disclosures of how to make and use an invention in the patent office. So every time that you write a patent or apply for a patent, you're also required to not only set out what you claim to be your invention, but to fully describe to others how to make and use it. And so if you look at the patent, you'll see this 15-page stuff before the claims with pictures and descriptions, and all of that is to satisfy that obligation of giving to the public this information of how to make and use the thing that you came up with. So a lot of people say the incentive and the reason why we have patents is to make sure that we're getting knowledge to the public. And all of that patent information is going to be publicly available and searchable at the patent office. So you deserve a reward for giving the work of your brain to the public.
So you
And
get
that
that.
reward, yeah,
And that's that you're the only one that can make it for a certain
yeah.
period of time. You're sharing it. Yeah. Okay. Okay. Then that's my understanding. I mean, but it's kind of shifted a bit, especially with the P tab. It
How so?
is well, it has become very easy for patents to be challenged, and the smaller, regular old first time inventor, if they get challenged by a to use the same, pharmaceutical thing like a Johnson and Johnson or a
Mhm.
PG&E, they don't have a chance. They don't because they literally can't afford it. They
Right.
can't afford to fight the case. And so all this time, effort, and energy that they spent trying to get this patent evaporated because big
Yeah.
company says no.
I think, that might be a rather cynical viewpoint on it. A
It
lot of
is.
times, independent inventors, you know, the process of this inter partes review at the patent office has made it a lot harder for independent inventors
Yes.
to generate income from their inventions. And part of that is that the amount that you're going to earn from royalties goes down. If people say, well, if you're going to charge me more than the cost to invalidate it, then I'm just going to go invalidate it. And so oftentimes, let's say if previously you were making $1 million a year in royalties from somebody after the creation of the post-grant review proceedings at the patent office, now you're only making $100,000 or $200,000 in royalties because that would be the cost in legal fees to invalidate it. But on the other hand, I wouldn't call them necessarily a complete, death squad for patents. A lot of people have called them that. But I think that independent inventors who can muster up the cost of defense, typically the range of $75,000, if you can do that, you can hold on to your patent through that process. It's a bit of a wild ride, but you can manage to do that and still be able to collect royalties on your patent.
We literally have Ajax in here. Ajax is the maker of the TD1, which can measure transmission distance of color and light inside a filament. And he said the fear of defending a patent is quite off-putting. I say this from personal experience in the decision process. And that's actually one of the main reasons that we as 3D Musketeers, instead of patenting some of the things that we come up with, we just blanket open source them and we publish it everywhere. We scream it to the heavens so that prior art is obvious and it is there, because if I can't afford to defend it, which we cannot, we don't have $75,000 to $100,000 of liquid capital to just light on fire in the hopes that we can maintain intellectual property. I'd rather ensure that nobody else could do the same thing either. Play the mutually assured destruction game. And it's not what I want, right? As a company, a patent is an asset in the books. It is something that you can use as a valuation of the business. But I, as a more or less, entrepreneur with a couple of staff members, bunch of part-timers, do not have the time, the money, nor honestly the patience to go down this road. It would just frustrate me that someone else is saying that all this time, effort, and energy that I put into it is not valid for some very specific, what I would likely construe as dumb reason, and say, F it, you get nothing.
Well, what a lot of inventors choose to do in that situation is to take advantage of options like financing and license back assignments. So basically, if you're a small inventor and you can't afford to defend against your competitors, the giant competitors, you can do two things. Find typically a law firm,
Mhm.
but sometimes they're financing companies specifically established for this, who would be willing to purchase the patent from you and give you a license back so that you can continue using it. And then you get outright cash for giving the patent to that law firm.
Okay.
And then in turn, the law firm is going to go then become what some people call a non-practicing entity, or more pejoratively, a patent troll, and will go and sue anybody who's infringing and take on that cost and that risk of potential invalidation. And then you, as the inventor, get your cash up front, and you still have the right to use
You get a
your
license to use
invention,
it.
and you have somebody out in the marketplace suing everybody else for using it. So it can be a pretty good win for inventors who don't have the means to defend, to file and then sell. And then you get that immediate cash. Now, what are you going to get for that? Depends on the risk of whether other people are infringing and how good the patent is. And
Right.
if you didn't use a good lawyer to draft your patent, it might be very narrow. You might not actually be able to sue your competitors for that, in which case the law firm is going to say, hey, this claim is too narrow. We're going to give you $5,000 for this patent. And you're like, that's how much I spent filing it. And they're like, take it or leave it.
Well, and
So,
that's the thing. Those law firms are operating from a position of power because they
yeah.
recognize that they can offer you pennies on the dollar and you can either take it or take your chances. And a lot of times people are going to take that deal. So, not a huge fan of that personally, because it feels like, they're getting taken advantage of. And this is one of those cases where there is no such thing as a perfect system, and every system is going to have flaws, and those flaws are going to get exploited by those that have the ability to exploit it. And if you tell me there are perfect systems, I tell you to look at our tax system, and even the medical system, right? The ability for companies to patent their their drugs, raise the price exorbitantly, and effectively hold people's lives hostage. I'm looking at you, insulin, because if they don't have it, they die. And I understand they have to recoup their costs, but then why are they not charging the same price in every other country in the world? It's because they can't.
I really geek out about this. So this is another one that I have. So I have, in addition to my intro class on patent law, I have a class called Innovation Law, which is a seminar where we go over the policy justifications of intellectual property.
I just want to like audit your classes now, just to sit in there and learn, because I just want to learn.
Anybody who wants to audit, there are auditing systems, and for people that are over 65, there are actually ways that they can audit it for free because it's a state university, and they have special programs available for the elderly to audit the classes. So I've had people as part of this quote Project 65. If you're an elderly person that would like to audit the class, you can often do that for free. So I encourage you guys to do that. I always welcome those students to come join my class. But I really geek out about this. This is super fascinating. I have a class session in innovation law where we talk about this kind of differential pricing in different regions and why it happens. And oftentimes the students at the end of it actually reach the conclusion that having different prices in different regions actually results in the best economic outcome, as long as you can have really good enforcement against what are called gray market goods, or goods that are legal in another country. They don't violate the patent to be sold there, and then you bring them and import them into a country where you're not allowed to import them. It's a gray market good. And you seem to be thinking that's kind of a funny.
I have a great example, and when you're done, I'm going to give it.
No, go ahead. Go ahead.
Okay, so I have a back injury, for those that don't know. I have herniations from L3 down to S2, with the largest being L4, L5, which is a north of 10 millimeter herniation with marked nerve impingement. So basically means I can't feel my legs very well. Okay. One of the key treatments that they're recommending right now is PRP and stem cells, right? Here in the United States, for me to get stem cell therapy, it is not covered by insurance because it is still considered experimental medicine, right? It's about $7,000. Colombia.
I had to do that for my son. We did stem cell therapy. I have a child with special needs, and we did stem cell therapy for him, and it's all out of pocket.
It is bloody expensive. And Colombia.
Yeah.
They're known for something other than booger sugar. They are known as a destination for stem cell therapy. It is more affordable for me to take 2 weeks in Colombia, get the injections, stay at one of the nice, and there are literally hotels and entire communities that are developed for this vacation with a surgery attached to it. It is cheaper to do that. And I'm told they're higher quality stem cells than you can get here in the States. I'm like, that seems broken.
Well, it's so fascinatingly, I think you'd really have to do a deep dive to understand it. But the way that I help my students understand it is through this article. It's called, what is it called? I'll send it to you after so you can put it in the description. But there's an article that's written by somebody who's examining the HIV drugs. And they wrote about how in Africa, there are people that are dying because they can't afford access to the frontline HIV drugs. When it comes to HIV, it's often a bit of a treadmill of whenever you start on one antiretroviral, it only works for a certain amount of time, and then you have to jump to another one. And over time, starting with the beginning of the AIDS epidemic, pharmaceutical companies who had the incentive of the patent exclusivity spent massive amounts of money pouring into research on treatments.
Yep.
The only reason we have those treatments is because people that are pharmaceutical companies loved the way that the patent system would give them back their money for their research. So we got these these treatments, and people are alive because of them. Now people that
fair.
have HIV are able to survive, and in the United States can live out an entire life with the disease without having the same kind of troubles that they used to have prior to these treatments. But there are places where they can't afford those treatments. And so once you get past the first line, the second line, the third line of treatment, you run out of options that are not subject to patent protection because they're still within the 20 years of exclusivity.
Right.
And for people that can't afford those prices, they will die. So what do you do in that situation? Do you say, well, we have to give them that treatment and we can do that without them having to pay? Well, if you do that, then it changes the incentives for the companies to continue to develop the frontline treatments.
Yep.
And we're going to stop getting those frontline treatments without government grant money or other sources other than market exclusivity to incentivize the research and development. So patents can be very useful for creating innovation, but it can also create heartbreaking outcomes where people can't afford to survive. And that's a very difficult position to be in. There are not a lot of good solutions. I think some of the only good solutions are for governments to pitch in, and if they want their citizens to have those frontline treatments, to pay for them.
And that is as close to politics as I will get on a talk like this. Yeah, and for everyone, I guess Duff is talking about how Canadians will go to the States for MRI, CTs, and CAT scans and all that because the wait times are so high there. They don't care about the price. They need the imaging, and there's a fault in that system too. There is no system that is faultless, and that's the big thing to point out here, that if there are loopholes and things that are being used and you don't like it, then that's why you should go register to vote and let your voice be heard. And if if this is something that you're passionate about, then maybe it is time to look at running for office and starting to play these games. And Josh Malone is in the industry of patenting, probably one of the more famous individuals that said, screw it, I'm fighting for the little guy. After he went through, I've spoken with Josh and his attorneys. I really trying to get them on this show because his attorneys love talking about the entire case and just how much of an absolute abomination that it was, or they felt it was, I should say. And his case is just crazy. If you want to learn more about it, he has an entire documentary called Invalidated. The title kind of ruins the entire documentary, but go for it. Listen to it, learn it, because it is the story of someone who should have been well protected by the system, and ultimately the system didn't really protect him the way that he was expecting, and ultimately he decided that he was going to take the success that he got from that and apply it back to make sure that what happened to him doesn't happen to anybody else. So I don't know what your feelings are on Josh, but I look at him as the fighter for the
I know
guy.
Josh, and I think that he does so much to represent the voice of independent inventors. They're not a huge lobbying group relative to the big companies that are lobbying in the patent space. You've got the entire pharmaceutical industry lobbying together on the same issues. You've got the tech industry generally lobbying together on the same issues, opposed to pharma generally. But independent inventors don't often have a huge voice. And I think Josh did quite a lot to ensure that independent inventors have a voice, because he was, willing to put his own time on the line to go make that happen. And now I think because of him and other independent inventors that have advocated for that group, members of Congress often will say on every one of these panels, we need to have a representative of independent inventors. And that didn't used to be the case before a lot of the work that Josh was doing. So it's really valuable. And I, as whether you agree or disagree with what he's saying, I think there's immense respect that you should give to somebody that says, hey, I'm going to go stand up for my beliefs and have such a big impact.
Yeah, Josh's impact has been measurable, which in the world of patenting is a very difficult, level to reach, right? There are a lot of people that have a lot of things to say, and I see a lot of you in the comments. I'm sorry, there's very little that I can do to solve the problems that you have when it comes to patenting. But for someone to literally effectively devote the rest of their life, you gotta be a real dedicated and motivated individual. So if nothing else, hats off to you, Mr. Malone. And when I connected with you on LinkedIn, I realized we have one connection in common. It's
Yeah.
Josh.
Yeah. Yeah. I will say one thing that the independent inventors are fighting for right now, or some independent inventors are fighting for right now, is some reform to what is eligible for patent protection. So part of the reason why we have the post-grant proceedings at the patent office is because decades ago, the Supreme Court issued a decision effectively saying that most software and business methods were not going to be protectable as patents because they were too abstract to be eligible for patenting under Section 101, which is the patent eligibility standard. And a lot of the patents that were granted under the system prior to that Supreme Court ruling were still out there floating around and would have been invalidated through a court proceeding if it had gone to court, but that's expensive. And a lot of people were advocating for cheaper ways to invalidate patents that were going to be invalidated at court if they went there, things like software patents.
Yeah.
And so, and I will say not all software patents are invalid, but this decision from the Supreme Court invalidated quite a lot of them. And the Patent Office essentially adopted this new procedure in light of laws that Congress enacted to find a quick and easy way without going to court to invalidate all those patents, targeting the ones that were going to be invalid if they were decided in court. Now, after all of that happened, now you have a lot of independent inventors saying, hey, it's not fair that the Supreme Court is saying that my idea is too abstract to be patentable and I want to be able to patent it. And I think that the inventors are saying, I think that this is contrary to the Constitution, which doesn't have a limitation on the type of subject matter that should be eligible for patenting. And so those inventors are now pushing for new laws in Congress to change the patent eligibility standards and say we should now have things like software and abstract ideas to a certain extent be more protectable in a patent space. And this is also really important for a lot of biological inventions because they're considered natural phenomenon. The Supreme Court has found that those are not eligible for patent protection, things like screening for diseases like breast cancer and screening for diseases in fetal DNA that's present in mothers. So people want to change that. And this is one area where if you care about this, go talk to your senator or congressperson and share your viewpoint on the pending legislation. If you care about this, there is pending legislation you can go talk to them about.
Yep. Register to vote, damn it.
Yeah.
We don't, ultimately your voice matters, and if you're not registered to vote, then no, you're according to the according to the voting system, no, your voice doesn't matter. But yes, go speak to your congresspeople.
Yeah, even if you're not registered, I encourage you to be registered, but let's say you get that person elected, or even if you don't, you can still reach out to the office of the congresspeople to get your voice heard. It's not just voting that gets the ideas through. We're a representative democracy. In addition to voting those people in, you have to talk to them and tell them what you want.
It's often good to make sure that you can explain it in a way that an average person will understand it too. Remember, the Congress people are often broadly trained. They're not hyper specific. So if you start citing off specific legislation and you don't provide what it is about, you're going to see glassy eyes. It's going to happen. So make sure that when you are trying to talk to the right people, that you know the audience that you're speaking to, and you can disseminate it in a way that they will understand it, right? If just the same way that you wouldn't talk to college students, the same way that you would talk to a group of 5-year-olds, although it depends on the college class, I guess. You know, you have to make sure that you're communicating in a way that is effective and gets your point across without losing the other side of the fence there, especially when you're trying to be convincing and say, hey, this broke, we need to fix it, like now would be great.
The way to do that is to go take a look at some of the pending laws, decide which way you want to go, and send them a quick message that says vote yes or vote no on, and then the name of the statute.
Yep.
And don't really need the rest of the explanation because they don't care. They're just tabulating it into a big spreadsheet anyway.
Yep, they're just running numbers to see, all right, who wants this more? Do they like this? Do they not like this? And then what are my opinions on it? Yeah. Politics are obviously something that's a big topic here in the United States right now, and it is something that we here on 3D Musketeers do our best to maintain as middle of the road as humanly possible. The only thing that we will tell you is get out and vote, and that's all that matters. It doesn't matter what you want, doesn't matter who you want, I don't care. We care that your voice is heard. So if you haven't, go register vote.gov, vote.org, one of the two, I forget. Mods, figure out which one is right, put it in the chat, because this is Cunningham's law. I'll be deliberately wrong because I don't know which one it is, and then they'll figure it out and they'll make it right for me. This is the great thing about, having people that love this kind of thing. We did have some other questions for you, but they're very much off topic, and it's why I've held them to the end. I gotta go scroll up and find it, because we have some musicians that identified something in your background. John Stern, I am going to likely butcher this, so please bear with me, said, is that a violoncello piccolo behind you?
No, it is a very small ancient cello. So it is a cello, but it is, you're correct, slightly smaller than most standard cellos.
Okay. And then the other question was from John Olson. He wants to know where you got the lamp. Everyone really likes this lamp.
Where did I get this lamp? That's a great question. I almost assuredly bought it online, but I don't remember what online platform I got it from. But if you just search like LED, I think I searched like LED ovals or something lamp to find it, and then just browse through. I might have gotten it on Overstock or something like that.
Because Mad Cat found it. He found it on lumens.com. It's a Cassini lamp.
Yes.
It's like $3,000.
It is inexpensive.
Okay. I didn't know. It's like, that's a $3,000 lamp. Like, oh, wow.
I didn't. So I really like my deals. I did not buy it directly from the website. I definitely got it on some sales website like Overstock, or sometimes like One King's Lane I sometimes use, or there are various places where you can get deals, but I don't want to highlight names that are not sponsoring this program, right?
No, but it's fine.
But
it's no big deal.
There are places where there are various places where you can get deals on overstocked items, and I did not pay $3,000 for the lamp, but I paid some crazy amount for it, but I loved it too much. But I got it on sale.
Amos is in the chat saying looks printable.
Oh.
And see, now that's the kind of attitude that I'm here for.
Yeah, you theoretically could. That's a great idea.
For those that don't know, Amos, can I tell people what you do or what you're working on? I mean, I'm going to show it at 3D Printopia, but I don't know if you want me to talk about. I don't know if I can talk about what you do, because it is super cool what this guy does. But he was also talking about. He said, "Sure, yes, okay, all right, gearheads." Or just general people, do you have a drawer in your kitchen full of random stuff? And it might have bolts and screws and crap in it, right? Yeah, Amos is developing a system that uses computer vision and a projector. You can put bolts out on a table, and the projector will tell you what they are. It'll tell you the size, the thread pitch. Is so cool. As someone with a bucket of random hardware, I am going to build one of these. It is such a cool thing.
Can you connect? Actually, it's crazy ask, but can you connect him with me, because my husband is developing comparable, like complementary technology to that,
Sure.
And I think they could probably benefit each other. So if you connect him to me, I will connect him to my husband.
Amos, just DM me on Discord. I'll make it all happen. Yeah, Amos is big with like he's done bolt sorting and screw sorting and things like that before. It is really, really, really cool. I enjoy someone that takes their level of, no offense, Amos, excessive knowledge about a particular topic and uses it to fix a real world problem that a lot of people in this industry are like, how many of you have a bucket full of M3 hardware because the little screw assortment that you had fell apart and you just put it into a bucket and said, I will deal with it later. Amos actually has a solution to this problem, and it is amazing.
Dude, it'll get rid of all the ADHD doom baskets.
I like my ADHD doom basket. Thank you very much. Baskets. Let's be honest. There's a few of them. Thomas says 1 bucket. Amos says the current version going to be at 3D Printopia doesn't have a projector, but does have a pick and place head to put things in bins. He's using a Lumen PNP, I believe, a pick and place machine specifically designed for that. JRT 3D says sitting next to a tub of a billion M3, M4, M5. Exactly. This is why we as geeks need this technology in our lives, and I love it so much.
This brings us back to patents, because there are some spaces where people will develop stuff without patents and some spaces where people will not develop stuff without patents, like pharma. But I'd be curious to ask, would he have developed the system if he knew that he was never going to be able to get market exclusivity over the system?
I actually don't think Amos is patenting at all. I think he's pushing it into open source. So
So in this community, it might be the case that part of the blowback against bambulab is because it's a community that is not one that relies upon patent protection generally and tries to adopt more of a cultural mechanism to try to give people credit, and that might not be something that people feel is compatible with the patent system. That's not true in every industry.
Yeah, I think because this industry was founded upon open source, a lot of us the old geezers in this industry, but let's go with seasoned veterans in this industry are very much like we prefer open source because, one, it just makes things way less complicated, but two, it allows the technology that we are building and building upon and is being built upon the shoulders of the giants of the RepRap Foundation and everything that they've done. And it's like we're continuing on that legacy, and Bambu is the first consumer grade, I'm putting very big quotes on that, 3D printer that is kind of founded upon closed source. They've taken a lot of open source and adapted it into closed source. That's all I'm saying, allegedly. And so I think the community is rallying behind Bambu because they've made a name for themselves as being the home 3D printer of the future, if you will. And they see this as a potential risk to the incredibly aggressive pricing and, of course, the availability, period. Right?
Yeah, there's such a hard balance when you're talking about if you have a culture of open source, what is that incentivizing, and who profits from that? And some people would say that open source, benefits people because it allows development of the technology by anyone without paying fees. But on the other side, a lot of people would say that the open source community is one that is one of privilege, because it means that the only people that can innovate are the ones that are willing to forego financial incentives for doing so, and only people from acting from a place of privilege can afford to forego the financial benefits of innovation.
There is a fun slight challenge to that, but also comes from a place of privilege, and it is literally the machine sitting behind me. The entire Prusa line of machines, they are all open source. And Prusa is a company of almost 1,000 employees based in the European Union. So they're not even taking advantage of affordable labor in Asia, right? But it's not like they were an overnight success. And as they say, overnight success takes 5 years, right? Bambu appeared to be an overnight success, but they grew much more rapidly than any other company has in this industry. Now, they hit the market right. They had the right marketing. They did everything right. Prusa is fully open source, and that's why a lot of the machines behind me have 3D printed parts, and a lot of them are not stock 3D printed parts. Coming up this week, we're going to be doing an upgrade for one of, well, maybe one of those machines, maybe not. We're gonna let the internet decide what we do this week. It's gonna be a 3 to 3.5, a 3 to 3.9, or the MMU3, all of which are fully open source, and you can download the files. The entire bill of materials for this printer is public. You can download. You can make your own circuit boards because the Gerber files to make those boards are public. You can make this if you want to. They're banking on the fact that it is so bloody difficult to make it that you don't. And unfortunately, it means that there's a lot of clones out there. E3D is kind of the subject of a lot of this, oh, we have to change our ways. E3D started as being fully open source. I mean, here is a legitimate E3D V6. And if it wasn't for the cat, this would be a fully cloned V6. But the heat block, she likes to rub her face on it, and it unscrews the part, so the heat block is somewhere on the floor. I'll find it after the show. But these are effectively identical components. It's just the quality of manufacturing. And E3D has had to go to this fun system of patenting, but licensing. And they're licensing at reasonable fees so that they can control the clones that hit the market, but they're not stifling the innovation of education and academia, where they're enabling this to still occur. And I think that is, at least in this industry, that to me is that right range of, I need protection, but at the same time, I want to give back, you know?
Well, you see this this happens a lot in the copyright space,
Okay.
but it can happen anywhere in intellectual property law when you are dealing with open source licenses or any other type of community-based licensing. Typically, the best way to protect it and to protect against people infringing your license is to have as a backstop that if they don't follow the licensing conditions, like giving credit or whatever it is that they've set as their licensing condition, that as a fallback, they have infringement of the intellectual property, which has much more severe damages than breach of contract. So typically, when really professional companies are using open source licensing or other community licensing, they're going to have the intellectual property protection, pay for that to be maintained, and then have very specific terms that say people that are using it according to all these terms get the license. If you're not, then you don't get the license and we're going to go sue you.
That's the right way. I don't know. Feels like there has to be a combination of everything, and again, no system is perfect. But certainly these next, 6 months to a year at this point with Stratasys and Bambu, that's really the deciding factor here, and what we can expect to come out of this, right? That's
we're not going to know within 6 months. I think
really,
we might not even get to the Markman hearing, the one where you decide the meaning of claims within that time. I think we'll probably still be very early on in the case then. So we've got,
wow,
60 days or so for the response, and then which could include counterclaims. And but maybe it doesn't. And then you could have a period of time where you're setting the case schedule, and then you can have a period of time for discovery, and then you have a period for dispositive motions. Now, Judge Gilstrap, all of that goes faster because you have to get his permission to do dispositive motions. It's not built into the schedule, which can add an extra 6 months onto the schedule. And he often denies people the ability to file those. So it could move faster in his court, but I think 6 months would probably be aggressive for getting clarity here. I think maybe 8 to 10 months for a very fast docket to get to the point of having clarity for how this is going to end up before the trial.
Okay. And so, and I will leave this up to the people in the chat and then in the comments later on, but if you want us to be covering the updates as they occur, please let me know, because I will probably have to keep bothering you about this, Christa, because that video, which I was pretty confident about, shows that even with my experience working with inventors, my knowledge is limited, and that limitation can be quite dangerous if I am confident about something that I am wrong about. A great example is, for some reason in my head and in the notes that I had written, PTAB was Patent Trials and Admissions Board. You big dummy, it's Appeals Board. We did not only did that get through? It got through on the review, where I normally catch myself making mistakes like this, and I didn't catch it. So
there's so many things to think. Don't blame yourself too much.
See, but the difference is, as a public figure, right? That's out there forever, and people that don't know any better take it as gospel, and they can now be confidently wrong because of it. So my goal is to produce corrections where we can. YouTube hasn't given us the ability to do those proper corrections just yet, but I fix it in other videos that people probably don't watch. But you know, I want to be accurate, and that's why we took as long as we did to make that first video about it, because I wanted to talk to patent attorneys locally, get their opinions. Of course, nobody wanted to go on record about that, so thank you for going and talking about this very publicly. Because I think it is important for people to be able to ask those questions, and if they are first-time inventors or they're wanting to get more, structured opinions from you, you have something coming up via Eventbrite, right? Can you talk about that a little bit?
Yeah, so on October 9th, in case people are interested, I'm going to do sort of a Q&A session. Legal information, not legal advice, but I'm going to provide basically an hour for people to ask me questions about the patent system for makers or other intellectual property issues for makers. I'm going to go over how open source licensing works, how you comply with it, and also how you get a patent when you decide that, how much it costs, things like that. And basically be around to answer any questions that people have.
Yep.
That maybe you don't want to pay the $500 something an hour consulting fee for a lawyer to tell you that basic information.
And while there is a cost to it, obviously it is considerably less than, engaging with an attorney. And so if you guys do want to take a look at that, it is linked in that description. So if you do want to see it, if you are watching after October 9th, sorry, this is what you get for not watching it live or listening to it the week after when it goes out on all the platforms via audio only. So, not my fault. And I know we talked about this, but are we going to be able to meet, well, at least your husband, but potentially you at 3D Printopia? Is that going to be a thing?
Probably not me, but I might send my husband out there. He's much more of a 3D printer aficionado than I am, but I've got a lot of obligations here with the teaching and with the kids, so.
Fine. All right, I'm going to give you some advice for that. Make sure that he doesn't take empty luggage.
Okay. Why is that?
Because it'll be filled by the time he gets back.
Oh yeah, there you go.
Because there are companies doing filament exchanges.
Yeah.
There's Printed Solid normally does a crazy deal like $15 a kilo in cash in hand kind of thing, and you take it from them. So that's why we fly Southwest.
He's definitely going to bring an empty suitcase.
Well, yeah, so 3D Printopia is coming up. If any of you all will be there, we will see you guys there. Christa, is there anything that you want to leave the folks at home with before we wrap this one up?
No, just thank you for watching, and please connect with me in any way you can. I've got my website, christalaser.com. I'm just starting out my YouTube channel. It's very, very early, but I encourage you to check it out and subscribe so that we can all stay connected.
Absolutely, guys. Check her out. Links are in that description down below. Remember to stay until after we do our sign-off. I have to constantly remind people because we're going to do a filament giveaway, but I end the recording for the audio only because they don't like it when we do the giveaways live. Christa, if you want to hang out for that, you can. You don't have to, though. Thank you so much for spending over 2 hours talking, very frankly, with just absolute professionalism while I'm over here talking like an Italian. Thank you for explaining this.
We need the balance because I when I talk on my own, it's just super dry. Like, let's go through the statute, hooray! And that does not keep people's attention. So I very much appreciate you being the one asking the questions because you keep it interesting and engaging.
Well, I think that's what people come here for. Although they really come here for when I just like let the Cuban in me out and not the podcaster that doesn't like editing, so does it live instead. But this has been awesome. Thank you so much. And this should be the last time that we do a live about the Stratasys first bambulab. But if there are any updates, I don't know, maybe we'll talk about it again on a larger format. But Christa, thank you so much for your time. Again, people, check out all her links in that description. Go subscribe to her on YouTube if you want to learn about law from someone who is not only a patent attorney, but also a college professor. So, you know, she actually has some proper ways to communicate to the average individual. But thank you all so much for coming out. Stay safe out there. Don't forget to call your loved ones. And as always, keep making awesome. Have a good one. All right, recording is done. It's time to let's give away some filament. How many rolls? How many rolls should we be giving away?
Pick?
Yeah.
5.
5? All right. We'll give away 5 rolls. I will give you all another, I don't know, 30 seconds to enter. We've talked about it like 4 times. You all should have entered by now. Christopher Elliott says 42. I don't have that kind of time, and neither does Christa. We don't have this kind of time. So all right, we're gonna do 5 drawings. I'm not gonna bother to check if you're in the comments. So, yeah. And have you all tried printed solid filament over there yet?
Oh, me? I'm trying to remember. I know that he really likes the Prussia stuff because he was looking at like what all these nice little colors and things like that. So I don't know if he's tried that particular brand.
Okay. So they are our filament sponsor. So they're made in Newark, Delaware, which is an hour and a half from 3D Printopia. Just say it. Like I said, make sure he doesn't take empty bags with him because they're going to get filled.
Now that you mentioned that, I guarantee he's going to do it.
So after the show, we normally go over to Printed Solid and Film, and they are a division of Prusa Research. They're actually going to be producing Prussiament here in the United States, which is
that's great.
Super freaking cool. All right, let me turn off the giveaway. Oh my, and there's 98 response. Someone just eked in right at the end for response 98. That is the largest giveaway for numbers that we've had. So that's all because of you. They don't come here because of me anymore. They've just given up listening to me. Let's see, 915. Who do we got? Max H, you were the first one to get in there, and Carl's Pena, you were the last. So I always like to say the first and last people to get in on the giveaway, because I think it's just fun for them to know where they were on the list. Let me get you all into the fun, fancy giveaway wheel of doom here. Or is my computer angry right now? Why are you angry? You're not that angry. You'll be fine, computer. Come on. All right, I'm just going to pick people. Oh, nope. Google Chrome is totally locked up. Well, this is a fun one. Isn't this fun when technology just completely bugs out on you and you're not able to do what you need? Okay, now it's working again. All right, 5 spools. Mods, keep track of who they are and if they're there. So, first one. Is it really is my accountant watching this? Shane Moore. I feel like this is okay. That's my accountant's name. Is my accountant watching my live stream? Okay, sure. Shane Moore, you win. I don't know if that is actually my accountant or somebody else that goes by that exact same name. Let me make sure that they did the math right. They did. So awesome. You get a roll of filament. Wonderful. Let's do the next one. We've got, let's see, Robert G. Let's make sure, I didn't check if they did the math right. I'm just going to assume you all did the math right. So, Robert G., you are a winner. Let me find your name on here, because if I don't do it, I'm not going to have it. And you did the math right. Great. I don't have to embarrass people. So there's a math question inside of the giveaway. And if they don't do the math right, they don't win. So that happens from time to time. All right, next one. We've got Cinnamon GTA. Cinnamon GTA 1. And we'll do number 4. All right, this is number 4. I think it's number 4. Number 4 is Joe Rust. I saw Joe Rust in there earlier. And we will spin for number 5. Number 5 is Gerwin MST. Sorry if I got any of those names wrong. So those are your 5 winners for Filament. Thank you all for coming out. Christa, thank you for spending time with everybody as well.
Thank you.
Steve Build's not streaming today, so you guys have the rest of your afternoon. Enjoy, take care, and have a good one. See you later.